Welcome to the Pioneers in Pixels audio podcast, hosted by Sanjay K Khetarpaal, CEO of Marketing Markers, a digital marketing agency. Here we have discussions with some of the leading attorneys. Disclaimer: the podcast is for educational purposes. Please reach out to attorneys for legal advice.
Good morning, everyone. This is Sanjay K Khetarpaal, and I own a digital marketing company and based out of Englishtown, New Jersey. Today, I have Ben Menasha with me. Ben is, rather than me explaining who Ben is, let's ask Ben. Ben, welcome.
Hi, how are you?
Great, thank you. So, Ben, before we start delving into questions about what you do, what actually you can help with customers with, let me understand who you are, what you do, why you do what you do, and kind of give us your story, give us your background.
Okay, so I am an estate and elder law attorney. So I am an attorney, and my office concentrates its practice in the areas of elder law and estate planning. That means that we help families plan for estates and their monies should somebody pass away or face significant illness, and try to preserve an inheritance for their loved ones. That's what we do.
Okay. So let's start with the very basic stuff. Why is it important? Why is it crucial for everyone and not just wealthy to have their estate planning? Why there is a misconception about it. So
there's a big misconception. You don't have to be a millionaire to have a will. If you don't have a will, the state is more than happy to say where your money goes for you. They have statutes on the books that dictate where all this comes from and where the money will go to. So if you have a child, for example, with whom you don't want to speak to, who you don't speak to anymore, and you make no appropriation in your will to not leave them any money, then if you don't make any appropriation, then the state is going to be more than happy to say that, yes, that child can get money. If you have a spouse or you have a child from a previous relationship and you pass away without a will, your spouse will not get everything that you have. And some of that money will go to that child from that first relationship. That may not be what your intent is. So to make sure that your wishes are really going to be reflected in your estate plan, it's best to have a last will and testament and go from there.
that's great. And I think I heard you talking earlier was about the power of attorney. A lot of people just assume that, okay, what if I'm not there, my wife or my spouse will be able to take care of it. Now, in absence of power of attorney, what is the significance of having a power of attorney? What is the importance to have one?
So let me take a step back and tell you that a proper estate plan stands on three legs, like a stool. Mm-hmm. It needs a living will or a healthcare directive. It needs a durable power of attorney, which is generally financial, and needs a last will and testament. The last will and testament doesn't mean anything till the day a person dies. The other two documents, the living will and the general durable power of attorney, those take effect during your lifetime and don't have any meaning upon your death. So the living will or the advance directive talks about how you want to be treated medically at the end of life in the event that you can no longer speak for yourself. What is a dignified death? How do you want to be on machines? Do you not want to be on machines, etc.? And the power of attorney allows people who you designate to have access to your money or to engage in activities upon your behalf based upon the powers that you give them in that document. So the document can either be springing or immediate. So as soon as it's signed, it can take effect. That's immediate. Or it can be springing where some other thing has to happen first before it takes effect. The document can be limited or broad in scope, which is it can be for one transaction, one bank account, for example, one financial institution, or it can be everything that you want to think about across the board. So for many clients, as you heard me say in the past, mm-hmm. they have retirement accounts, for example, or stock in their own name. And if they become ill or they're unable to access their own money due to their own infirmity, then somebody has to be able to do that to help them out. They will not have the ability to do so without that power of attorney. If the person can't still help themselves and there is no power of attorney, then the next step is to turn to the court system and have the person declared incapacitated through a guardianship action. And that's where it becomes a very public notice as to your own incapacity.
Interesting. So the other question which comes to mind is really saying that, well, if I have a power of attorney to the spouse, and in the event that spouse is also not there, or what something happened at the same time, what do the statutes say now? What was going to happen? Is there
if you and I are married and I had a 401k or an IRA and I turned sick and you're my spouse and you needed money from my IRA to pay the medical bills, you would not be able to get any access to it because you're not the owner of that 401k. Okay. The only way to do that is to have a proper power of attorney in place to ensure that you can have access to it and do what you need to do at that time.
So now here's a situation that you said you and I are married and we got into a car accident. Both of us are like incapable of making the decision and I'm the power of attorney. And what happened? Like who makes a decision in those cases? Is there
So when we draft the documents, we actually put in more than one person in succession. So if not you, then somebody else. If not somebody else, then another person.
Okay, so there's a chain there. Okay.
Yeah, so we really try to make sure that in the event of that kind of disaster, there is somebody out there who would be able to act.
So now let's take a next step in this one. How do estate planning needs changes, or does it need changes? And I think it does, but just want to hear from you that as one ages, because there are events happening there, how often I should do it, or is there a directive, or I just wait for the event to happen? What is your suggestion? What are your thoughts?
So there are different times and different scenarios to cause someone to look and redo their estate plan. If you're talking about a young family, it's going to be when a child is born, when a house is purchased. You want to make sure that if you just got married, that it is your spouse who's the beneficiary of your life insurance and your 401ks and your IRAs and not your parents. You're going to want to, if you have more children or once you have a child, you're going to want to put in guardianship provisions and trusts for the benefit of your child, so that there is money to take care of them and somebody to take care of that child. As you get older and as things mature and you amass more money, you may or you may not have a tax issue. And so we'd have to examine that. The tax world is constantly changing. Currently here in New Jersey, we don't have an estate tax anymore. We still have a transfer inheritance tax. So if you decide to leave monies to nieces and nephews and friends, that tax, or brother-in-laws, sister-in-laws, brothers and sisters, the tax will hit. So we need to understand that issue. On the federal level, the taxes are constantly changing on a regular basis, and they're set to change again on January 1st of 2026. And they're going to go down in the amounts that you can shelter. So it's going to be important to understand how much that you have, how much you think you're going to have. And that's why every so often we tell people every 3 to 5 years, important for them to re-examine their estate plan. Also, illness. If somebody is diagnosed with chronic illness, things like dementia or Parkinson's or
Alzheimer,
Lou Gehrig's disease or anything like that, anything that robs you of body and mind or is going to start doing that, it's important to get your affairs in order. Maybe we might want to do some Medicaid planning or things like that. So it's important that we want to take a look at your assets, see what needs to be done, and maybe revamp the will a little bit, maybe revamp the will of the spouse if there is a spouse, and to talk about and see if everything's properly in order to address the situations that are now.
Interesting. So while you were talking about that, I just thought of another thing, which was like in your previous statements, you mentioned that like if you don't have a will, now state makes those decisions. Is there a order of preference the state have, like, hey, listen, if you and your spouse both are not there, the next thing is your kids, or if you don't have any kids or you don't have any spouse, somebody else, like maybe parents, I'm just guessing here. Is there something like that existing so that I know what it is going to be, what is it going to happen? I just want to be aware.
Well, every state has it designed differently. These are called the laws of intestacy. And so when you die, it's your last will and testament. And intestacy means when you die without a will. And yes, here in New Jersey, we look to see if you have a spouse Do you have children? Or all the children of this one union or not?
Hmm.
If there is no spouse, it goes to the kids. If not the kids, are there grandkids? If not there, we go up to the parents. If not the parents, we start looking to descendants of the parents.
Like siblings and stuff.
And those are known as laughing heirs because they're laughing all the way to the bank. They never expected to see a dime from you.
Right. That's fun. So what role an estate planning attorney plays in helping the clients? What once they come, once they know that, okay, you know what, I probably need one. What do they need to prepare? What role you play in their things? How should I prepare myself to even see you? I mean, it's kind of a multiple questions in there, but kind of on those
It's
lines.
a good question because you see, when people call our office, we send them a questionnaire. I need to understand their family dynamic, and their assets and how much they have and how it's held. Is it held jointly between husband and wife? Is it held solely by one of the spouses? Are there beneficiary designations attached to the asset? Because all these different things are going to affect how it flows and how it's going to happen upon death. If my clients come in here and they have a child who's facing addictions, we may not want to necessarily leave them money, but we might want to leave it in the form of a trust. If there's a child who's a special needs child or on public benefits, perhaps we want to leave them their money in a special needs trust. There are different issues that I need to understand. Maybe there's a child who is a debtor and has bad debt, or maybe they're in a bad marriage. These are all things that we need to understand because we don't want to see the hard-earned money that the clients that work for disappear due to their child's circumstances as much as possible. Now, understand that an inheritance is not a guarantee.
Oh,
Your money is yours during your lifetime. We want to leave money to our children. And yes, we feel that's the way it should be. But sometimes we need our money. And we should not enjoy our money because we are afraid that we want to leave more of it to our kids. That is not really the best way to proceed.
yeah, I understand. And I was talking to my father the other day, and he was saying the same thing. Like, you enjoy now versus waiting to give money to the kids. But
Right.
anyways, that's a good point.
Because many parents see that as their legacy.
I know, I know. It's there. It's their love or whatever. But some of our like people are changing, mindset is changing. So maybe they'll be better. You talk about trust when you were talking about various type of trust. What are the different type of trusts which I should be aware of as a? I mean,
There are so many different kinds. Basically, understand the trust is a world that you can create. It is a box, basically. Under common law, to create a trust, you just simply say, I'm creating a trust. And now we have the Uniform Trust Code here in the state of New Jersey, which kind of helps us understand more formally how to create a trust and what it's about. And essentially, once you create that world, then you can tailor it for the purpose for which you are creating it. So are you creating something to help that child with addiction, to help that special needs child, to deal with estate taxes, name it, to keep it in the bloodline so it doesn't go to other people? Is there a young child who would be getting the money, but we don't want them to get the money so quickly, and that money can be used for their education and their health? There are all kinds of different reasons to be thinking of, why do I need a trust? Many people say, I need a trust because I want to avoid probate. And probate is the public transferring of title upon death. And that's done in every state. So if a person has property in New Jersey and in Pennsylvania and in Florida, their house and that real property in each of those states has to be probated in each of those states. So if those states are court-oriented versus administrative, New Jersey is administrative, you're going to want a living trust, a revocable trust, in order to prevent going through their court system.
interesting.
Trusts are either revocable or irrevocable. Irrevocable trusts are trusts that once you put the money in, don't come back to you. You lock the key in the box and you throw the key away or give it to somebody else. Re means you still have control of the monies of that trust during your lifetime.
Interesting. So there was another thing I was thinking about when you talk about trust, and you mentioned financial part of it earlier also. So I was thinking on those lines, like what are the financial implications of estate planning, including potential tax savings or any other expense? Can you talk about that a little bit?
So taxes are It's a loaded question
It's a,
on that whole question. The truth of the matter is that for many people in the last few years, it's not so much the estate taxes or estate tax avoidance, but you're trying to avoid with these taxes, these trusts. It's dealing in addressing any income tax issues might come out of them because trusts are taxed at different rates than people are. So sometimes you might want to create an intentionally defective trust so that it's taxed at the rate of the grantor. You might not be able to do it that way. And the Medicaid rules, some people take the position that it may not be advantageous to have some of those provisions in the trust, that it could negate the trust. So there are all kinds of different things you have to weigh in and take a look at across the board. So it's complicated because the rules are complicated, because taxes are complicated, because situations are complicated. So you really have to understand what's going on in front of you to know what path to take and how you're going to be taking it.
Interesting. See, when I'm hearing all those things, I would like, if the person who is not doing any planning or any estate planning has not been done, seeing all of or listening to all of this information, it's like, it is overwhelming for a lot of people. Like, okay, you know what? This is a lot of things. And how do I approach this? And you know what? Before even somebody gives you a call and reach out to you, they have to convince themselves that this is what I wanted to do it. So some of the information around the web is so overwhelming. So any thoughts, any advice you want to give to the listeners saying that, guys, I know that is overwhelming, all these things, but take it step by step, or whatever you wanted to guide. How would you guide? What kind of advice you will have for those people? I just want to see the people coming over. I think this is important for them. This is very critical, but they feel overwhelmed and they keep on pushing it forever.
So there is a lot of information on the internet because every state does it differently and there are different rules in every place. Sometimes what you hear online and see may not be applicable in the place where you live. So it's important to understand the basics. I would pick up a book. I would go to the library or the bookstore and a book on basic estate planning and concepts. And then I would start meeting with a professional with whom you trust in order to get your estate plan done. Beware of somebody who doesn't ask you about what you have when you want to do your will. We had people in my office about a month ago who had seen an attorney. They did a will for them very quickly. And then they came in from last year. They just came in again. They said, we want to update our will. And I started asking them all kinds of questions. And I started to understand that there was family property in different places, that there were different familiar relationships going on, that certain people weren't talking to each other. And before I knew it, I was asking such probing questions that they looked and they said, our other attorney never asked us any of this. And now we see that the plan that they put together really doesn't reflect what we really want of everything you and we've been discussing. So it's really important to be able to communicate with your estate planner all these different issues in the family dynamic and your assets, so the plan can be properly tailored to those individuals and their particular situation. I wouldn't be doing my job if I gave everybody the same will that accomplished the same thing for everybody.
No, I understand. I think it makes sense. And you know what? Just by thinking on the same line, you talk about the other attorneys, but I was thinking about being a digital marketing guy, and I was trying to see what is available on the web. There's so many different companies who have started to come back with saying that, hey, you can have your will and all of this done on the website. And it's a pretty standard form. They have it. And then you go ahead and fill it with, it's a questionnaire kind of thing. You fill it up. So at some point, I believe that they didn't ask me all those questions, which they should have asked, because I finished that form really, really quick. What is wrong with that system? I mean, is that something people should try to do that? Or
no, we've seen plenty of those wills come through our office over the years, and they're not drafted properly, or they think they make sense to what they're saying, but it doesn't fit and conform with the way the law works, or they're not properly notarized or witnessed. I mean, there's all kinds of different issues across the board with these. I've never seen one that's been done properly and correct. And here people are thinking they're doing something and they're saving a buck. They're not. And then it becomes difficult because, for example, I've seen people go on these services and they'll draft a power of attorney. Our attorney will say no gifting. Well, gifting is a very interesting issue because you don't want to always give somebody the ability to gift your assets, and I understand that, and give it away. But if you're coming in here because you now have been diagnosed with dementia or you've been diagnosed with some kind of chronic illness that's going to rob you of body and mind, you're going to want to have those provisions in there so that we can properly divest you and take advantage of all the different Medicaid rules, if necessary, in order to try to save some money one way or the other. Sometimes, for example, I just simply saving the house in New Jersey by transferring it out of both spouses' names and into the healthy spouse's name. The power of attorney needs to say gifting and allow for gifting, and not just annual exclusion gifting, with it's limited to, which is, I think this year's around $17,000. Gifting for the purpose of public benefits, and it's got to be specific in what it says and allow for the transferring of property. If it doesn't have some of these elements in that document, we can't use it. So we need to be sure. So these companies that are drafting these documents are drafting them for themselves to protect themselves from any liability, but it may not be acting in the best interest of the person who's trying to use them.
Well said. Well said. So pandemic hit. Did you see the changes the pandemic brought in on this? Either the laws which have been there, like people were following the laws, or the state laws have been changed, or the way you talk to your clients or things like that. What has changed for you because of the pandemic and the technology taking a decade leap?
So we do a lot more client work online through video conference. People are more open to that idea. So that works well. But you need to be in person in our office when you sign our papers. During the pandemic, they tried to have some kind of notarial way to write a will and things like that, but there were deficiencies in the rules that was drafted here in New Jersey. So my preference is still to have all the documents executed in person in front of me, so that I can attest to how things happen and what happened, etc., and answer any questions for the clients. But during the pandemic, a lot of people did not want to do people weren't going to nursing homes. People were trying to stay sick at home as long as possible because they were afraid to go to the nursing homes and assisted livings because they were raging with COVID, kind of a thing. And that was a big stress on a lot of different families as they tried to take care of their loved ones in those home settings. But that's really what it is. We're kind of back to where we were pre-COVID in terms of the work that we do and people looking at different places and alternatives. The only main difference for us nowadays is that the families and clients are more willing to engage in a more online
video conferencing stuff, you said.
Yeah, exactly.
Okay, that works out. So looking forward, what changes do you foresee in estate planning laws and practice? Do you expect any changes coming up which can impact or you as a person or a customer or anybody else? What do you
So taxes the federal estate tax threshold is going to be dropping, as we said, starting January of 2026. So that's a huge issue coming down the pike.
Right.
Public benefits for people who need to be in nursing homes and things like that, those rules are constantly changing. So we always have to stay on top of those. So nothing in my world ever stands the same. Yeah. The planning that I do today is not the planning I did 5 years ago, and it's not the planning we were doing 10 years ago. Okay. So it all depends. The world is constantly shifting. That's another reason why we tell people to reevaluate their estate plans every 3 to 5 years.
Okay, good. One more thing is, before I ask one, there are a couple of more questions. I've seen people who are like Gen Zs or millennials and people like that. They generally don't care at this point until they reach a certain age. Like, I'm going to be 55, 60. Let me talk about my planning and stuff. What are you doing for that? Is there a right age, or what is the right age for starting the things or thinking about it? Because I believe that when you're in 20s, you don't really care. At some point, you're like, oh my God, it's too late now. Is that something like that? Is too late or too early?
It's never too late. It's only too late if you lose mental capacity.
All right.
But where are you in life? Are you a young influencer who made money as a teenager and now you're a millionaire at 22? Yeah, you need a will. Are you just starting out, or are you in college and your parents need to have access to your assets, or not just that, have access to your medical records so they can talk to your doctors for you. Maybe you need a living will and a HIPAA release form. There are different things that are different reasons why you should be thinking of things. It's not an age. It's not a whatever. It's where am I in life and what's going on and what do I need in light of my station in life at the moment. Okay. And again, yes, many people do start to think about their wills and their estate planning in their 50s. I can't tell you how many people come into my office who write down a quick will when their kids are born and keep it in a corner or someplace in their drawer, only then to pick it up 30 years later and start laughing and say, this is what we put together. We should really be more serious about it and go see an attorney.
Yes, yes. So another final question. So this is about, since this is a digital marketing guy taking into, how is digital marketing, or is digital marketing helping you? Or if it's not, how can it help in what you do? Sorry, go ahead.
Educating the public in what we do is always good, whether it be in-person talks and presentations to people, whether it be word of mouth. Who do I talk to? Who did you use? Seeing my name. It's not unusual for people to say, I got your name from 3 different people.
Right.
I heard your name here many years ago. I heard you speak many years ago. It's all about, when I first opened up my practice more than 20 years ago, at the time it was somebody needs to hear your name 3 to 5 times before they give you a call or they know about you. I think that is still true. People need to know about you and they need to hear about you in different ways. Yeah. So that's kind of, marketing is always important to keep doing.
Yeah, you're right. It says about 7 times. If you hear that same name about 7 times, people just make that decision. So talk to me about that. There was a recent award you got, if I remember correctly. Was it recently? No. Last year. Okay, maybe I'm mistaken.
No.
So thank you, Ben. This has been great information. I can keep go on and on. There are so many things I can ask, but I just want to keep it smaller too. So tell us about how, if somebody needs help, how can they reach out to your phone, your emails, your website? How do they contact you?
So we are accessible by all those different places. Our phone number is 732-246-4110. We're based in North Brunswick, New Jersey, but we help everybody all throughout the state. Our website is www.pandmlawyers.com. That's pandmlawyers.com. And you can always reach me by email at bmenasha, that's BMENASHA, at pmlaw-nj.com.
Okay, great. Thank you, Ben. Thank you for your time today. I appreciate it. Thanks so much.
Thank you.
Thank you for tuning in to today's episode of Pioneers in Pixels. We hope the discussion was enlightening and informative, giving you a clearer insight into the complexities. Remember to subscribe to our podcast on your favorite platform and never miss an episode. Join host Sanjay K Khetarpaal next time for more insights and interviews with leading legal experts. Until then, stay informed and empowered. This has been Pioneers in Pixels. Thank you for listening and have a great day.